Welcome to this estate planning 101 session here on the 980s podcast station. We appreciate your time. I apologize for some of the uh, technical disruptions there, and we had to reshoot, re-air this because it wasn't actually doing correctly. But at the end, welcome back to this estate planning, protecting your family, your wealth, and your legacy. I appreciate you guys and your time today. Again, throughout this webinar series, we have discussed tax planning, retirement tax strategies, and planning opportunities for businesses. Today, we're bringing all this to a head through the estate planning process. Estate planning is often viewed as something that only matters when you die, but in reality, it's about maintaining control, protecting your family, and making sure the wealth you spent a lifetime building ultimately transfers according to your wishes. Many families spent decades accumulating assets, but very little time planning how those assets will be managed if they become incapacitated or how they'll be transferred to death. That lack of planning can be or can create an unnecessary situations, probate, taxation, delays, legal expenses, family conflict, a lot of unintended consequences that we can alleviate. And that's what we're here to talk about today. So today we're going to discuss how to avoid many of those common mistakes. Now, as you know, I'm Kevin Thompson, founder of 99 Capital Group, host of 98's podcast. I've been in multiple publications here. I'm an enrolled agent, a CFP, a retirement income certified professional. That is my cohort that I normally work with, are people that are out in their retirement and business owners as well. And of course, our mission, helping people make smarter decisions and avoid paying additional taxes other than what they technically owe. And again, if you have any questions, feel free to contact us on our website at 99 Capital Group, 99, sorry, 99capitalgroup.com and schedule an appointment. So what you're going to learn today in today's webinar, again, it's not designed to turn anyone or everyone into an attorney. The goal here is to help you understand the questions you should be asking and the conversation you should be having with your estate planning attorney, CPA, or financial planner. We're going to discuss the core estate planning documents, how wills and trusts differ, which assets avoid probate, why beneficiary designations are so important, and how taxes can affect your heirs ultimately, especially in regards to step up in basis and things like that. We'll also cover some of the most important and common mistakes I see and conclude with a practical checklist you can use to review your own plan. So one of the biggest misconceptions, and again, I find in estate planning is that it only deals with what happens after you die. Estate planning also protects you while you are alive. Suppose you become seriously ill, which is absolutely going to happen. Most here's the thing. Most people don't understand that you're going to become ill or temporarily incapacitated prior to your death. That's the majority of us. Who has the authority to pay your bills? Who has the authority to communicate with financial institutions, manage your investments, or make healthcare decisions on your behalf? Without the proper documents, your family may have to go through a court process before they can legally act on your behalf. A comprehensive estate plan addresses incapacity, healthcare decisions, asset management, the transfer of property, and the legacy you want to leave behind. This is why estate planning is not simply planning for death, it is about lifetime planning while you are breathing. So, here are 6 documents that can form the foundation of a comprehensive estate plan. A revocable living trust may be appropriate for someone who wants to avoid probate for properly titled assets, maintain greater privacy, manage property in multiple states, or provide more detailed instructions for beneficiaries. However, not everyone needs a trust. Nearly everyone should consider having a will, financial power of attorney, medical power of attorney, HIPAA authorization, and advance directives. The appropriate documents will depend on your family situation, the assets you own, the state of residence, and what you're trying to accomplish. Estate planning should never be treated as a one size fits all exercise. Now, each document plays a different role. A revocable trust controls the assets that actually have been transferred into it. It can also provide instructions for managing those assets during incapacity and after death. A will addresses assets that remain in your individual name and are subject to probate. It can also nominate guardians for minor children. A durable power of attorney gives another person the authority to handle financial matters if you cannot act for yourself. Medical power of attorney identifies who can make healthcare decisions on your behalf. A HIPAA authorization allows the people you designate to access protected medical information. An advance directive communicates your wishes regarding end of life care. The goal is to make sure someone has the legal authority to act when it matters most. People often believe they must choose between having a will or having a trust. In reality, many comprehensive estate plans use both. A will takes effect after death and generally directs assets that must pass through probate. It can also nominate guardians for minor children. A revocable trust can operate during your lifetime, provide management during incapacity, and continue after death. However, simply signing a trust document does not automatically avoid probate. Assets must be transferred into the trust. Otherwise, nothing really happens. I like to explain it this way. Creating a trust without funding it is like buying a safe and never putting any money into it or anything inside of it. It doesn't have to be money. The document may exist, but it cannot control assets it does not own. Probate is the legal process used to administer someone else's estate after death. The court may validate the will, officially appoint an executor or personal representative, allow creditors to submit claims, and authorize the distribution of assets. Probate is not automatically terrible. Its cost and complexity depend heavily on the state, the size of the type of the estate, the quality of the estate planning documents, and whether the family members disagree. In some states, probate can be relatively manageable. In other situations, it can be lengthy, expensive, and public. The goal is not necessarily to avoid probate at any cost. The goal is to understand which assets will be subject to probate and make an intentional planning decision. Again, not every asset passes through probate. Retirement accounts like life insurance typically transfer directly to beneficiaries named on the account, assuming the beneficiary designation is valid and the beneficiary survives the owner. Transfer on death, payable on death accounts can also transfer directly. Assets properly titled in a trust may avoid probate because the trust already owns them. I go back to the trust does not own anything that's not titled to it. Joint property may avoid probate when the ownership structure includes a valid right of survivorship. The details matter. A retirement account without having a living beneficiary may still end up payable to the estate. A trust cannot control assets that it was never transferred into it. I'm going to say it time and time again. Joint ownership also does not always include survivorship rights. How an asset is titled can matter just as much as your estate documents say. So beneficiary designations are one of the most overlooked parts of the estate planning process. Someone may spend thousands of dollars creating a will or a trust, but never update the beneficiary form completed 10 or 20 years ago. Things have changed, everyone. For many retirement accounts, life insurance policies, annuities, and transfer and death accounts, a valid beneficiary designation generally controls who receives the asset. That means the beneficiary form may control the outcome even when the will says something differently. You should review your primary designation, your beneficiary designations, contingent beneficiaries, percentages, trust designations, and whether you have selected options such as per stirpes. Employment retirement accounts may also have special spousal requirements. The beneficiary form may look simple, but it can be an enormous issue if done improperly. Every major life event should trigger a review of your beneficiary designations. That includes marriage, divorce, the birth of a child or grandchild, the death of a beneficiary, the retirement or a change in your family. Moving to another state should also trigger a broader review of your legal documents because estate and probate laws vary across the states. Do not assume that divorce, marriage, remarriage, or updated will automatically correct an old beneficiary form. The results can depend on the type of account, federal law, statutes, the plan documents, and the specific circumstances. The safest approach, everyone, is to affirmatively review and update every designation. Outdated paperwork can completely undermine an otherwise well designed estate plan. Now, most Americans will never owe federal estate taxes. For 2026, the federal basic exclusion is about 15 million per individual, so most Americans won't hit that. Although previous taxable gifts and other rules can affect the calculation. However, avoiding federal estate tax does not mean taxes disappear. Beneficiaries may still face ordinary income taxes when they withdraw from inherited IRA accounts. They may face capital gains taxes when they sell inherited assets that appreciate after death. Some states may also impose their own estate and inheritance taxes. For most families, the income tax treatment of inherited assets will be far more relevant than the federal estate tax. This is why estate tax planning and tax planning must work together. The basis adjustment at death can be one of the most valuable tax benefits available to a family. Suppose someone purchased an investment for $100,000 and it was worth $600,000 at death. Eligible inherited property will generally receive a new basis to its fair market value at death. If the beneficiary sells the investment shortly after for approximately $600,000, there will be little to no tax on the capital gain. However, any appreciation after the date of death may still be taxable. It is important to understand that not every asset receives this treatment. Traditional retirement accounts, annuity gains, and certain other assets generally do not receive the same basis adjustment. Knowing which assets receive a basis adjustment can materially affect gifting, charitable contributions or charitable distributions, and inheritance decisions. So I want to say, and let me get this out of the way here, because I think it's in the way. Not every dollar that's inherited has the same after-tax value. A traditional IRA is generally taxable as ordinary income when the beneficiary takes it upon distribution, except for any after-tax amount that's basis. An inherited Roth IRA may provide income tax-free qualified distributions, although inherited accounts, the deadlines still matter. Eligible assets held in taxable brokerage accounts may receive a basis adjustment at death. This means $500,000 traditional IRA may not provide the same after-tax inheritance as a $500,000 Roth IRA or a $500,000 taxable investment account. This becomes especially important when parents are trying to divide assets equally among children. Equal account balances do not always produce equal outcomes for taxes. So the Secure Act and the subsequent inherited account rules significantly changed retirement and estate planning. Many non-spouse beneficiaries must fully distribute an inherited retirement account by the end of the 10th year following the original owner's death. However, the rules are not as simple as waiting just 10 years and taking it all out. That could be a huge tax bogey. Annual required distributions may also apply depending on whether the original owner had already reached the required minimum distribution age. Special rules can also apply for surviving spouses, minor children, and other disabled individuals, chronically ill individuals, and beneficiaries who are close to age to the deceased owner. The timing of inherited account distributions can push beneficiaries into higher tax brackets. This is why inherited IRA, like I've always said, the planning around it should involve both the financial planner and the tax professional. Roth conversions is another one here. Can sometimes be a valuable part of legacy planning. The basic idea is that an account owner may voluntarily pay taxes at today's rate in exchange for moving money into a Roth account at a later date and provide tax qualified distributions. This can be attractive when the owner expects to pay lower taxes than the beneficiaries, but um, that's only if it's beneficial in their situation. And again, it's a tax arbitrage. And you can say, oh, well, I'm paying lower taxes than my or higher taxes than my beneficiary. That's fine. But in most cases, you can kind of see who's gonna have to be in which tax bracket. Because Roth conversions are not automatically beneficial. The analysis should consider the owner's current tax bracket, the future required minimum distributions, Medicare premium exposure, available cash to pay the tax, state income taxes, charitable intentions, and the beneficiary's expected tax situation. The owner's retirement security comes first. The potential benefit to heirs should be considered only after determining that the strategy works for the owner. So your estate planning team, again, many estate planning problems are not caused by the complicated tax rules. Common estate planning mistakes that I've seen, they're caused by simple mistakes. Some people never create the necessary documents. Others created documents decades ago, but never implemented them or updated them. Beneficiary designations may still have former spouses, deceased family members, or people the owner no longer intends to inherit the asset. Some people name primary beneficiaries but forget to name contingent beneficiaries. Others create trusts but never transfer assets into them. Estate planning is not something you complete once and forget it. You have to be looking over this every single year. Your plan should change as families change, life changes, assets and laws change. So, like I said, your estate planning team is a strong estate planning is usually a collaborative effort. The estate planning attorney drafts the legal documents and ensures they comply with applicable laws. The CPA evaluates the tax consequences of gifting strategies, trust structures, retirement distributions, and transfer of assets. The CFP helps coordinate the legal and tax recommendations with broader financial plan. That includes investment accounts, retirement income, insurance, beneficiary designations, charitable goals, and family priorities. Problems often occur when each professional works independently and no one looks at the entire picture. The best results come when an attorney, CPA, and a financial planner communicate with one another. So here are several practical steps you can take. First, review the beneficiary designations on every retirement account, life insurance policy, annuity, and transfer and death account. Second, review your estate documents and confirm that they still reflect your current family situation and wishes. Third, make sure your power of attorneys, your identify people who are still willing to and able to serve. Next, review the retirement tax treatment of the assets your family may inherit. Fifth, organize the legal documents, account information, insurance policies, and key contacts into a secure location. And finally, tell the appropriate family members where those materials are stored. A perfect estate plan is not helpful if no one knows it exists and cannot locate it when needed. Estate planning is not primarily about death. It is about protecting the people you love and making difficult decisions easier for them. You have spent decades building your financial life. You should take the time to make sure your assets transfer according to your wishes rather than do outdated paperwork, default state laws, or assumptions that were never reviewed. An estate plan cannot eliminate every challenge, but it can provide clarity, reduce confusion, preserve more of what you built, and give your family a roadmap during a difficult time. Ultimately, estate planning is not just about the money, it is about the people the money is intended to protect. Thank you guys for joining the final installment of this webinar series. I hope today's discussion gave you some clear understanding of how wills, trust, beneficiary designations, probate, retirement accounts, and taxes all work together. Estate plans, tax laws can be varied across the states. The assets you own and the individual circumstances are yours and yours alone. The information discussed today is for general educational purposes only, should not be construed or treated as personalized tax advice or legal advice or investment advice. Before making any changes to your estate plan, beneficiary destination, or tax strategy, consult with a qualified legal, tax, and financial professional. Thank you again for your time. I'm happy. And if you have any questions, feel free to send them to our email, which is listed at info@99capitalgroup.com, or go to the website and schedule a call if you want to have an introductory call at www.99capitalgroup.com. Thank you guys for listening. Stay humble, stay safe. We'll see you again soon.